You are watching Germantown Municipal Television, your source for everything Germantown.
Hello and welcome to Law Talk on Germantown Municipal Television. My name is Vince Perryman. I'm a local attorney with the law offices of J. Vincent Perryman. Each month, Law Talk focuses on a wide range of legal issues and topics. On today's show, we'll discuss copyright law. With us now is attorney Neil Perryman. Neil, thanks for being with us.
My pleasure. Thank you for having me.
And for anybody that's wondering, we're not related.
That we know of yet. I mean, I know we're still looking into it, but for now, we are not blood related as far as we know.
So, copyright law, it's probably something everybody's heard about copyright, at least when they've read a book in high school or whatever. They see the little copyright thing there and all sorts of copyright stuff. But it's one of those things that I think there's a lot of misconceptions about it and what is copyrighted and what rises with the copyright, and just where would you begin when somebody thinks they've got something with copyright?
Well, Vince, it's kind of interesting. So, copyright law comes about because we want to protect an individual's creative work, right? Mm-hmm. It's meant to encourage people to create art or music, which can sometimes be the same thing, software programs, literary works, things like that. And it's meant to incentivize them, to give them certain rights and privileges with respect to that work, to incentivize them to continue to produce. For instance, to be able to make money off of it, to be able to sell it, to use it the way that you want it to be used, to with music, to perform the music, to be able to have it heard. If it's a play or some other type of production, those performance rights that are built into it. Mm-hmm. A lot of people sometimes mistake copyright for being that which is just on the page, but that's not in fact true. There are other areas of copyright law upon which it touches. Now, a lot of people think, big question I always get when folks come into my office is, when does copyright protection attach? Mm-hmm. Well, copyright protection attaches the moment you create it. And that's a really commonly held misconception. A lot of people think they have to go through all these great measures to get copyright protection, and that's not in fact true. Now, with that said, if you're going to want to use the copyright infringement statutes of the United States Code, you are going to have to go through a registration process with the Copyright Office to make sure that your work is properly registered. Mm-hmm. And there are a lot of rights and privileges that go along with that registration.
Yeah, and I think that's always something that's really interesting, because you get people that they think they can copyright something that they may not be able to, and then you have people that are like, well, I don't know if I have a claim because I never copyrighted this, and then you explain the whole, it arises from all of this. Right.
Well, okay, there's two things that registration really does for you. One, it allows you to sustain an action for copyright infringement. You cannot, if I don't register my work, I can't sue you for infringing on my work later on down the road, okay? So in order to sustain that action, that cause of action, or a lawsuit, as usually folks in the non-legal community refer to it, you're going to have to register your copyright. Now, there are also some damages issues. How much money can you get from your lawsuit, or what type of money you can get from your lawsuit that's associated with copyright registration. It's temporal as well, and by that I mean, you've got it from the creation of the work. Usually it's creation or first publication, which publication meaning the first time it was put out into the public. Public could be from individual to individual, not necessarily to the general public. Mm-hmm. You have a certain time frame in order to register that work, in order to take advantage of statutory damages. See, the copyright statute has two sets of damages: your actual damages, which what you actually lost from the infringement, which can also sometimes include the infringer's profits, which is really interesting sometimes. Okay. But there's also statutory damages. Within the Copyright Infringement Code, it specifies how much money the court can award you per act of infringement. It can go down For innocent infringement, like if you didn't really know that you were infringing and you happen to, it can be from anywhere from $0 to $750. For just regular infringement, it can be anywhere from, I believe, $750 to about $30,000 per act of infringement. And then for actual willful infringement, which is a higher standard that you have to prove, as you well know, it can go up to $100,000 per act of infringement. And the classic example I always use for, well, what is per act of infringement? Every single time that cover band plays that cover song, that's one act of infringement. Every time you download that song, that's one act of infringement. Every time the radio plays it over the airwaves, that would be one act of infringement every single time.
And don't forget the guys with the jukeboxes that don't ever pay back the royalties.
Yeah, well, those are a whole different animal in and of themselves. But what's funny about that is a lot of owners of establishments like bars and restaurants and things like that, they don't understand what their obligations are with respect to copyright law. You would think that it would be incumbent upon the band playing the song to carry the appropriate license, because how are you as the establishment supposed to know what music they're going to play, right? That's not in fact the case. In fact, the establishment has to carry the license. Now, if you go to the copyright website, you'll see like a BMI or an ASCAP. Those are a lot of companies that manage the licensing rights for artists and large record companies and stuff like that. You go to their website and they've got an exhaustive list of purposes for copyright. I mean, I think I was reviewing it one time and they even had a copyright specific to, I think, clod hopping contest. Like that was actually one enumerated in the list. And then of course there's going to be restaurants, bars, nightclubs, things like that. And it's not a base fee. There's a big algorithm that they put together based upon what your revenues are, what your capacity is, what your market is, things like that. And that's how they develop this license. A lot of times if you sign up for like a business license, you have your paid for streaming services, Pandora, Spotify, things like that. They actually have a business license you can purchase from them for their services, and that business premium will actually help cover the licensing fees through the payment of those premiums to Spotify, Pandora, whoever. They'll then forward along to whichever BMI, ASCAP, whoever, and that'll afford you the appropriate protection that you need.
Yeah, when we're talking about copyright, I think one of the things I see people do all the time is they try to use copyright and trademark interchangeably, but they are two separate and distinct things. I am correct on that, right?
Yeah, you're absolutely correct. So your trademark is going to be, your image, your logo, right? I mean, what sets you apart? What do people see? Copyright can be your slogan. It can be, the book that you wrote, the manuscript that you put together. You could, even to a certain degree, copyright like a reference book, like a phone book or something like that. Now, that's going to get into a later part of our discussion about what is protectable, right? So just because you filed a copyright and it was registered and you got your copyright protection doesn't necessarily mean everything within that work is protectable, right? There's this big battle between what is idea and expression, right? You can't copyright ideas. I mean, like if I had an idea to write a book, well, I can't copyright that and then forever charge every single person that ever wanted to write a book.
I got you. Yeah, and we'll take a break, and when we come back, we'll talk more with Neil about copyright law. Please stay with us.
Every year, 40% of all food in the U.S. never gets eaten.
40%. That's almost half the food we produce.
Food waste is a serious problem. It impacts all of us.
And it's expensive. Your family is throwing $1,500 a year in the trash.
We're working hard to put food waste on the chopping block.
And you can do the same at home.
Learn how to cook it, store it, and share it.
Just don't waste it.
Go to SaveTheFood.com.
When I was in foster care, I never knew when I would have to move. So I always had my suitcase ready to go. Then one day I was adopted. My new parents opened their hearts and home to me. My parents cook my favorite breakfast for me every morning. My parents take me on trips I never thought I would go on. They gave me a home and an even better reason to use that suitcase. My parents aren't perfect, but they're perfect for me.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. I'm Vince Perryman, and you're watching Law Talk. Joining us on our show today is attorney Neil Perryman, and we're discussing copyright law. Neil, before the break, you broke down for us basically the basics of copyright and how this is one piece of intellectual property. And then now I guess it's time to sort of start transitioning into what can you protect under copyright and what you can't.
Right. So, as I was stating earlier, there's this distinction between what is an idea and what is an expression, right? Mm-hmm. The expression, the artist or author's creative input is what's going to be protectable, subject to copyright protection, so long as it's original and meets certain other elements within the long history of case law associated with jurisprudence associated with copyright infringement. So what you've got is, like we were talking about, idea, right? Mm-hmm. Like I can't copyright the idea of writing a book, right? I can't even copyright the idea of two star-crossed lovers engaged in a family war, right? I mean, obviously I'm making an allusion to Romeo and Juliet here. However, even that great idea up here is not copyrightable. Mm-hmm. The expression of that idea, the particular scenes that you put together, the way the story unfolds, the plot, the family names, all of that kind of stuff can be copyrightable. It's kind of interesting. What you have at the very top, you've got the grand idea, right? Mm-hmm. And at the very bottom, you've got the finest detail of expression, the individual words on the page, right? Well, those aren't subject to copyright protection either. I can't copyright the word "the" or "a" or "an" or even Vince for that matter, because that is a name in and of itself. It has no individualized expression. It's not creative in and of itself, right? Not to say that you're not a creative person, Vince, but you get where I'm going with the name.
Yeah.
So, what do you do from there, right? Well, somewhere in between there is where you reach that plane of copyright protection, right? Somewhere between this grand idea and this base level expression is where that level of copyright protection exists, okay? Now, that's a very simplistic way of explaining the leading case law on what they call the abstraction, filtration, comparison, analysis. Now, that's going to get hyper technical for any author or anyone creating and hoping to get copyright protection for their work. But I can tell you right now, if you walk into a copyright attorney's office and you bring up the abstraction, filtration, comparison methodology, and they look at you with a blank face and don't know what you're talking about, that's the moment you need to get up and get out.
Walk right back out.
Turn around and leave. Go back to Google, do whatever you need to do, and find another copyright lawyer.
Right.
So you spoke a moment ago about how copyright is but one area within this larger umbrella of intellectual property. Mm-hmm. Trademark was one that we spoke of a moment ago, right? Patent law is another area that comes up quite frequently. And a lot of times in the case law precedent, the jurisprudence associated with patent law can be applied within copyright law. Now, patent's going to be more particular to the processes, the schematics, the hardware, if there is hardware that you put together. That's where you would patent that, right? You would patent an object, typically. It's the easiest way to draw the distinction, right? You're not going to copyright a special rake that you made that maybe nobody's ever thought about designing a rake that way. You would patent that, right?
Right.
However, there are times when patent and copyright intersect. Almost sometimes it might seem inextricably, and that's where an effective copyright law or patent law attorney comes in, and they're able to pull those apart, separate them in distinct elements, right? Now, this is where it gets interesting, okay? And I'm going to say interesting with a grain of salt because I'm about to start talking about computer software source code.
Yeah.
Okay? Now, you might think, okay, yeah, that makes sense. You should be able to copyright your computer program. I mean, you've probably bought Microsoft or their Windows or Office or some equivalent program at some point in your practice or even in your personal life, right? Well, all of that is subject to copyright protection. But it's not just that. It's the things that you don't see as well. The technology in your watch there. You know, that's running software scripts, source code, APIs, which are application program interfaces, things like that that allow the software and the hardware to interface and work together. It's what makes the stuff pop up on. It's what makes your phone communicate with your watch and allows you to send that text message and view that text message and respond. All that is subject to copyright protection, right? So then when I was talking a moment ago about idea and expression, well, in that world of software computer programming, that's where it becomes very, very important, right? Because there are a lot of things that are not subject to copyright protection in the world of software and computer programming and stuff like that that people need to know about. Just because you have a program and just because someone copied it, even if they literally copied it line by line, like they just took your software code, ran it through a copy machine and called it their own, that's still not necessarily going to be protectable because you've got to be able to reduce it down to the elements of expression that are particular to the individual author or artist. I even consider software programming, as odd as it may seem, to be artistic in its own way. Because, you know, there are going to be things like efficiency and programs that work better than other programs. And, you know, those guys make a lot of money. I mean, Silicon Valley wouldn't be as valuable as it is today if it weren't, you know, some sort of artistry involved in it. So, you know, that's where those distinctions become really important. And what's interesting about the world of computer programming with respect to copyright law is, you know, it's always kind of been a square peg in a round hole. Because computer programs are starting to get to the point and always kind of have, they don't fit perfectly within that sort of that frame of copyright law. They actually treat them as what they call literary works. So they treat computer programs like they would treat Romeo and Juliet, right? Now, Romeo and Juliet's in the public domain. That's a whole conversation for another day. But with respect to public domain, which that means is that at some point, you're going to lose your copyright protection. Right now, I think it's from the death of the author plus 72 years. Don't quote me on that. I'd have to look at that. It's been a minute since I've looked at it. But
we'll give you a second to look at it while we take a break. When we return from our break, we'll talk more with Neil about copyright law.
I'll be right back.
Hi. You think you're probably sober?
Yeah.
But you're thinking about taking the back roads home, just in case. If you're probably sober, then why would you do that? Good choice.
Probably okay isn't okay. If you see a warning sign, stop and call a cab, a car, or a friend.
That's a full glass of wine. I'll be chatting you later.
Did you know parking over tall, dry grass can spark a wildfire?
Only you can prevent wildfires.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. With us now is attorney Neil Perryman, and we're talking about copyright law. So Neil, before I abruptly cut you off in the last segment, you were getting into talking about software and technology in regards to copyright and what was copyrightable and what wasn't, I think.
Right. Well, what I was explaining is that under the law, they treat software programs like literary works. That's what they, and that's actually defined within the copyright infringement code, okay? The term literary works, that's a work of art within the term of art within the legal community, okay? But that's kind of like I said earlier, a square peg and a round hole, okay? Because technology is constantly advancing, right? Literary work was meant to define like a book or a script or a play or something that's kind of written down and never really changed from that point forward, right? But as you well know, I mean, how many times have you had to update the software on your iPhone or on your iWatch or something like that? I mean, how many times have you been in the middle of writing a brief and suddenly Microsoft Office decides it wants to completely reboot your whole program and give you the blue screen for a little while? It's constantly evolving, and that's why it doesn't really work well within that literary works context. Plus, up till now, the reason it did kind of work is a lot of software source code is in written form. It's A's, it's B's, it's C's. We're not talking about binary code, the ones and zeros that you saw flowing up and down the screen on the Matrix. I'm talking about actual coding that people could read. That your typical programmer is going to work with, VB6.net or VB6, VB.net, things like that, MS-DOS, stuff like that.
Fortran, if you're that old.
Fortran, if you're that old. Hey, I recently had a copyright infringement case where we had to deal with Fortran, believe it or not. It dated back that far. But the point I'm making is that now technology has outpaced the copyright law to the point where a lot of your new, and by new I mean some of these programs are 20 and 30 years old at this point, are graphical. There's a program called LabVIEW. It's developed by National Instruments. It's graphical programming. So you no longer have your lines of code like you would expect to see it spit out on like a dot matrix printer if you remember those. But it's going to be almost like squares and lines that connect them, and they have these equations built in and things like that. So, the question becomes, have we reached a point to where software and computer programming has outpaced copyright law and it no longer falls within that literary work definition? And if it doesn't, now what do we do? And that's a big question right now, actually, within the legal community, the copyright infringement, legal community, with, especially on the litigation front, because we're the ones that are having to deal with these tests, not the guys that are filing the copyright registration applications. It's those of us who are actually in the courtroom arguing with the judge and the attorney and the other attorneys and things of that nature that are dealing with these questions, and it's quite fascinating because those cases are now coming to the courts. And what do you do? I mean, if you can copy it, but make it look a little bit different, it's still copied. And copyright infringement actually gives you a right to derivative works as well. So if it's derived from your work, that's still infringing.
Yeah, and I would think eventually it'll go the route of what we saw with music, where it is if it's this many bars, then it's a derivative work. But if it's not, then it's not. Because I think about if you Google the song, That's How Strong My Love Is, written by a Memphian, Roosevelt Jameson, very nice fellow.
Okay.
And there is one that is covered by Alicia Keys.
Okay.
But it's not a cover because it's like one bar and then she changes everything and goes back to the one bar. So there's no royalties coming off of it.
Well, the classic case most people probably remember is going to be Pressure, written by David Bowie and Queen, and then the Vanilla Ice song, Ice Ice Baby. And I think they even argued, no, there's one more little beat in there. There's one more little beat in there.
Yeah.
That's kind of the classic example, though. But you're kind of right in that sense that we are reaching a point, that it's going to have to evolve. Copyright law and the jurisprudence with it is going to have to evolve because technology is outpacing it every single day. Like I said, that LabVIEW program I spoke of, that thing's been around since the 80s. And just now is it starting to come into the courts on copyright infringement.
Yeah.
And we're going to have to deal with that at some point. Fortunately, in the most recent litigation I had, it ended up not being as much of an issue, but that doesn't mean it's not going to be at the next one.
Right, and the question that comes to mind with me, because I do a lot of non-competes for guys that are doing software, we always have that thing in there about they, won't take any proprietary software, or this or that, and they won't use what they've learned here over there, and it's kind of one of those like, how much of the language of proprietary software tracks with what's copyrighted?
Well, for the most part, a lot of it, because that's going to be the original written expression of the author or artist, as I spoke of earlier. What's interesting about those non-competes, and this is what you really need to focus on when you're drafting those, okay? That proprietary software actually starts stepping off into another realm of intellectual property law that deals with trade secret misappropriation. And it would be important for even the transactional lawyer writing employment contracts, contracts with vendors or customers, things of that nature, to make sure that they are tracking what measures the client is taking in order to protect their trade secret. Now that's really important, and I want to explain this for anybody that's submitting an application for copyright protection where there may be some trade secrets they want to protect. You have to redact those trade secrets from whatever you submit to the Copyright Office for copyright protection, because if you don't, you've placed it within the public domain and you've therefore taken away the protection of the trade secret statutes. That's very, very important for any individual, especially a lawyer, because if they don't know that, I mean, you've arguably committed malpractice at that point, and that's a whole boat that nobody in our business ever wants to get into.
Well, unless you're Glassman and you represent the attorneys that committed the malpractice, but that's a whole different story.
Well, then, of course, and I hope he's not watching this show so he doesn't latch on to some of my colleagues who are submitting those applications.
Yeah.
But
So, yeah, and it's one of these things, it's a really interesting topic overall, and sort of as we wrap this thing up, I think it's always important to explain as to why you want to find an attorney that does copyright. They know it, so that way you don't get hemmed up.
Exactly.
So you got about 15 seconds.
Okay, well, the reason you want to know it in 15 seconds is because you don't want to be in court one day and find out that your lawyer messed you up on the front end and affected your ability to protect yourself and to protect your money. And that's ultimately what it comes down to.
Right. So, our time is up for this edition of Law Talk. I'd like to thank our guest for taking time out of his busy schedule and being with us and sharing his thoughts and insights. If you would like more information about Law Talk or any other program on Germantown Municipal Television, please refer to our website at www.gmtvonline.org. Thank you for joining us today, and be sure to join us next month for more legal topics. Until then, I'm Vince Perryman, and thank you for watching.